Memo bi akwaba eba Melodies TV so ensem esisi na miana mese mepe Melodies for nso mo aka tremese mo de be mame mebema mo tiase se Ghanaian professor friend Professor Azar ababe petition president say only a year chief justice in Frio. Last 2 days, maybe a story on Chief Justice. Ye pesi ye ni free hoa process ben ene wose ye femwa ye de be Chief Justice no. Na me mamoti asese process no edi kan ene se e wose will be a petition a year omampenyi a wote so. Inti no professor yi ababe petition omampenyi a wote se Chief Justice no edi nyamransem bi na eno hunti yenyi ni free ho mebe ma moti asese se mo pese me kenkan enkrata ni na montro 1 na 1 nso de ngrofo bebre atro 1 na chese mo pese me kenkan enkrata no nti quickly yenko enkrata mu ni nkuhu papa ne nsem a waka now or say petition for the removal of the Honorable Chief Justice of the Republic of Ghana, Her Ladyship Gertrude Saki Tokonu CJ, pursuant to the provisions of Article 146 of the 1992 Constitution of the Republic of Ghana. Also, introduction. I, Professor Stephen Kweku Azar, a citizen of the Republic of Ghana, respectfully submit this petition to Your Excellency, the President of the Republic of Ghana, seeking the removal of Her Ladyship Gertrude Saki Tokunu, the Chief Justice of the Republic of Ghana, on grounds of I, stated misbehavior, II, incompetence. Inti the entire yesi yenyi Chief Justice no ensem mienu 1 or say ni suban fin bia wada ne di 2 say maame no woni medjuma. Okay, yenko so say the legal basis of my petition is Article 146(1) of the 1992 Constitution of the Republic of Ghana, the Constitution. For the avoidance of doubt, my petition focuses on stated misbehavior and incompetence related to the Chief Justice's administrative functions as head of the judiciary responsible for its supervision and administration under Article 1254 of the Constitution. Into your threat, say to me a man ekwan say wo to me throw petition we ema president no Article 146. Na sa Article 146 yi and America say 2 days ago me baba kenkan tremo say Chief Justice need the bonani epese yi na de ebeya ye be yi no aha into no. Now, the third point was in my petition does not arise from the Chief Justice's exercise of her judicial functions. Accordingly, the petition does not challenge any decisions, orders, or directives issued by the Chief Justice in the performance of her duties as a justice of the Supreme Court, including those made to enforce judgments, decrees, or orders in cases she has adjudicated. I fully understand, respect, and value the importance of decisional independence. Samuni Amobekaya, they now may breakdown on how to remove the Chief Justice. Make can say nipa kra wo be petition no. O making sure say petition no, it is not based on Chief Justice no the ruling be our make because nipa kono kokko yes na it will serve a bad precedence. Not just say later say Chief Justice bi babium ni epese ye na ye beka say asem we esan say when di ni say ye pese wudi ni say awokodi ni say ntina ye you, it is a bad precedence. Nipa bonifo ba benya tumi a obetumi dey threaten Chief Justice bi a ebia asem aba ono aka ni ye ni ye dey isa Chief Justice na free so nti munya moka ya mekansa asem no nti papa no Professor Kweku Azar ensem a woka ne say Chief Justice no pese ye ni free no o ma nkrofo atiase say enye say Chief Justice ni ruling bi case bi a wakwa kodinti na yesi yenyi na dabi enye case bi a we di ruling bi a we di ne enkoka say ruling nti Chief Justice na ni suban bi a wadan ne di eno nti hono no person grofo etiase. Now I say it is my understanding that upon the receipt of this petition, Your Excellency shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom you shall appoint as chairman, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. See Article 1466 of the Constitution. It is my further understanding that the committee shall inquire into the petition and recommend to you whether the Chief Justice ought to be removed from office on the grounds maintained in this petition. I affirm my understanding that all proceedings herein shall be held in camera, and the Chief Justice is entitled to be heard in her defense by herself or by a lawyer or other expert of her choice. The process na meka kire bono. Yes, Chief Justice ye pesi yi na omo e wo so motena board so omo a e wo se president ni omo kasa ati ase in camera na to say ye mo wo bia nsem no nti ye no na wo ka say we read the constitution no na wati ase say the ebesi no. The said point or say, it is therefore my understanding that Your Excellency the President of the Republic of Ghana, Your Excellency, shall act in accordance with the recommendations of the committee. Nti send ya work and we expect to say committee no emma recommendation na president no be di so, just as I said 2 days ago. Now background. I say a request for appointment of 5 justices of appeal to the Supreme Court. Into your consent nimu Chief Justice no esu by Bonnie was say Chief Justice ne din ne din ti was say yen pameno no enumu na woko. Or say Chief Justice no request say yen fa judges 5 from appeals court Embra Supreme Court. Or say by a letter dated 30th May 2024, the Honorable Chief Justice of the Republic of Ghana formally wrote to Your Excellency, especially requesting the appointment of the following 5 judges of the Court of Appeal to the Supreme Court of Ghana. To Trim say, on 30th May, Chief Justice no etro letter eko koma President Akufo-Addo say, one 5 judges being bra Supreme Court. We yensemo ayaka ewo platform we so. Ankrofo bebre na aka setia. Enti no wabo judges ni din. We no ka say, regarding His Lordship Edward Amoako Asante, the Honorable Chief Justice wrote that Justice Asante Asante's term of office at the ECOWAS Court ended at 31st July 2022. He was requested to remain at post on account of the withdrawal of Mali, Guinea, and Burkina Faso from the community. His current tenure is expected to end in 2026 or earlier when he is expected to return to Ghana's judiciary. The letter goes on to say that His Lordship has provided excellent leadership as President of the ECOWAS Court and will undoubtedly be an invaluable asset on the Supreme Court of Ghana. Regarding His Lordship, Justice Eric Chebafo and the leaderships Angela Mensah Homia, Sarah Pamela Cranton, and Efua Asari Botwe, however, her leadership, the Chief Justice, wrote that they are currently working as justices of the Court of Appeal. Their work has been distinguished by outstanding service, courage, and competence. The grave nature of the Chief Justice's role in requesting the appointment of the said justice to the Supreme Court became evident when subsequently social media published another letter dated 7 February 2024 from the Chief Justice to Your Excellency. The letter of 7 February 2024 is captioned, "Brief on the need for the minimum number of 20 judges on Ghana's Supreme Court bench." In the said letter, the Chief Justice states that, "I write in reference to our previous discussion on the Chief Justice's proposal for an increase in the number of justices of the Supreme Court of Ghana. Kindly find attached a paper justifying the need for the request. Thank you very much." The above quotation quotes that there has been a previous discussion on the subject between the Chief Justice and the President. Or say, of concern to your petitioner is the fact that both letters, one proposing an increase in the minimum number of justices on the Supreme Court of Ghana and the other requesting 5 specific judges to be appointed to the Supreme Court, were written on the letterhead of the Chief Justice and clearly expressed itself as the Chief Justice's personal request on the matter. The letter did not refer to any consultation or involvement of the Judicial Council, the council of which the Chief Justice is a member and within whose constitutional mandate it lies to deal with matters relating to the appointment of justices of the Supreme Court. Your petitioner is further concerned by the reference to an earlier discussion between the Chief Justice and Your Excellency the President on the proposal to increase the number of justices on the Supreme Court. Your petitioner also notes that the question of minimum number of justices on the Supreme Court is settled by Article 128(1) of the Constitution, which provides that the Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. The plain meaning of Article 1281 is that the minimum number of justices for the Supreme Court is 10. Thus, an amendment of the Constitution is the lawful way to change the minimum, not by a private discussion or communications between the Chief Justice and the President. It is Parliament that has the power to amend the Constitution. Now, for people who don't understand what's going on, my kinkain, but my main trim, I say letter be PA. And Chief Justice no catch President Kufuor say, me pese what the judges 5 eba beka Supreme Court judges ye wie ne sanso hu another letter Chief Justice no wo kasa on the limitations of a year Supreme Court say omuhia say on the President Kufuor edin kan ya kasa de dada say wo hia judges inti ne judges no wonye na President Kufuor nye den appoint judges ne ntem na ho na papa yi Professor Azar say, in the first place, the appointment of judges no, any kwan say Chief Justice no, any a catcher president. Judiciary no, omo board be a show mo so. I from the judicial board, right? Omo board a show mo so. The General Legal Council, the General Legal Council. The judiciary no board the show so from the General Legal Council. Say omu hia more judges a General Legal Council no and there was a request and the Chief Justice. It is a Chief Justice no use the letterhead e the actual letter ama President Kufuor say wo hia judges no entwa ye. In that's the first point on that matter. The second point on that matter they say Ghana Mra Okoti article 128.1 what say Ghana Mra say judges of the Supreme Court yen fakra no eni kwan say ebro 10 Supreme Court judges no eni kwan say ebro 10 ono nenti ase of Ghana Mra article 128 no say eni kwan say judges no ebro 10 judges e wo ho now what sanso kasi ye befa 5 judges wo catch president say one fa 5 judges in beka ho na tre say wo no wetiambra embra tre say ni kwan say ye fa judges e bro 10 wo catch Kufuor say one fa 5 judges in bra beka ho ebe ma judges na wo Supreme Court na bro 10 dia na tre say Chief Justice wo say embra no wo ti ase no wetiambra intinanka wo pe more judges e wo say Parliament e na approve na Parliament ma yeti access okay ya amend the law no nti sisi ade ebetumi the judges egum but wow de wo pe akwa trauma president no so one for 5 new judges in become number 10 na nti aga na mbra article 128 ne dia na che say ejuma no nimu atre say o die suban bi edia entwa ye nti wo see you free ho as Chief Justice ne point no I hope so be at here or say further. Your petitioner has reliable information that at a meeting of the Judicial Council held on 14th June 2024, the Chief Justice expressed her desire to increase the number of Supreme Court justices, whereupon the Council advised her ladyship to pursue broader consultations with other institutions on the matter, especially the Parliament of the Republic of Ghana. At the said Council meeting, the Chief Justice did not disclose the fact that her desire to increase the number of Supreme judges had been the subject of a previous discussion and a communication with Your Excellency. This fact became evident only after the letter dated 7 February 2024 from the Chief Justice to Your Excellency appeared on social media. Wait there, we reveal secret and nim. Into say Chief Justice no any General Legal Council no kwa twetwe nkomo. Ekatro mo se o pese President Kufuor do more judges eba Supreme Court ho. And a General Legal Council for ne catch and say, hey, wait there, yes, raw. Upeso ye bibi sa, a Jew call Parliament too. Because it's yambra, a Jew call Parliament. But omo catch and the mammy went ye. Say what wrong crat and the quad dada and son or catch General Legal Council for no. On ye Kufuor do hum como crat the dada and son or catch General Legal Council. It's an actress say, when ye Parliament, when ye General Legal Council ne futu awo mama na General Legal Council claim him say the na ma me ne ye no it's yambra. This is serious. If indeed evidence it to me show say the General Legal Council advising say onko parliament na wanko na still or yeah any dia we there is serious at you say we there is serious. Now I say 19th point no. In any event, your petitioner has reliable information that on the 24th of June 2024, the council met once again, and her ladyship then presented the names of the 5 justices for the council's approval. In so doing, her ladyship gave the impression that the names presented to the council for approval emanated from your excellency, which then would mask her role in requesting for the appointment of the judges. Now, Chief Justice, no, or say Chief Justice ni him say, Chief Justice, ena catch president say president emfa judges embra inti maame ne ye ne nyama wieye no owie na 24th June okọ General Legal Council for ho na odi edin no ekọ ye say oh President Akufo-Addo person appoint judges eba Supreme Court no mudin ni onim say okọ say eyo no no person de judges ne ba o meka say ye boni nti no wa hyeda akọ trom say Akufo-Addo mi wa no no afa tire na wa throw letter ma Akufo-Addo say judges am person o de ba eni nti ehɔ no saa de na wo ye no na tese wo nimpanse wo di bɔne nanso wo kɔ so koko di bɔne no chale nsɛm hyehyɛ ho. I said the constitution requires the president to act on the advice of the council in consultation with the Council of State when nominating Supreme Court judges for parliamentary approval. The Chief Justice elaborate scheme of requesting the president to appoint specific judges and later presenting these names for the council's approval subverts the constitutional scheme and converts both the council and the president into rubber stamping her preferred judges. As it turned out, this scheme was fortuitously undone by the council's concern about the timing of the nominations. When the petition is being considered at any stage, members of the Judicial Council will be subpoenaed to testify on the matter. Inti oka woka say sa petition ya wodema president say omotena asem ne so na omo frɛ na members of the Judicial Council so ebeto nsa frɛ omo no mo aba testify say indeed, and you see sa Legal Council for ni omo committee na ye omo true minutes so me ba testify say indeed ye ka kyerɛ maame ne say na nka mo onye end of okokɔ ye nti no clearly na be show say maame no di bɔne ati ase nti no this is serious. Also, the Chief Justice's request for the appointment of the aforementioned judges to the Supreme Court was done in brazen violation of the constitutional rules for the appointment of justices of the Supreme Court, amounted to abuse of her office, and was done without fair or reasonable criteria. Into what I say, Chief Justice Nadia Waye with Tiaga Nambra. Chief Justice the Nikwanse with Tiaga Nambra. So say mbra nidi. The Chief Justice's request for the appointment, the Chief Justice, as the head of the judiciary, must understand that she has no direct role in recommending individuals for appointment or promotion to the Supreme Court. If the Chief Justice makes recommendations for promotion or appointment to the Supreme Court, it strongly indicates either a shocking lack of understanding or utter disregard for the constitutional process and established promotion procedures. Further, the Chief Justice ought to know that she cannot have a side deal with the President to raise the minimum number of justices to the Supreme Court, sidestepping the minimum that is specified by the Constitution. So, Chief Justice say, Ghana mbra sebe enye nkwasiafo na etroye. Nyanse nti ena omanfa nhye Chief Justice nsa se wono ena wonma yemfa nkrofo mbra Supreme Court. Because yenim se ye de sa 2 minute Chief Justice bi nsa ono nkwa ne namfofo ne nkrofo nkwa ana wanhwe ye kra na ono Chief Justice ni betumi akwa koji sika won nkrofo ho na ode omo aba beto Supreme Court ho. Nti Ghana mbre nim sa nti yamfa sa 2 minute nhye Chief Justice ne nsa tinanka o se Chief Justice ni hu ne se saa de na wo ye no nanka otia embra kese a ewo oman ni mu nanso still okoso eyeye owie ye no sanso ka kire Chief Justice say o se Chief Justice ni hu se wono de ne pe ka kire President Akufo-Addo ni ye increase the number of judges at the Supreme Court e ade bi etia mbra or no in the position of Chief Justice no anka oso ohu anka eni kwan so masa ade ne yeden ekoso atiase and this is serious. I say arbitrary reconstitution of panels and transfer of justices. You know, we're raising the first issue. Our first issue, no, with the Chief Justice appointment, no. Now the second issue against the Chief Justice, once I can or say or no there, any ruling be a Chief Justice a ruling, any case be a Chief Justice a ruling na or Babeka Hansem Dabi a issue sankasa. The second issue I will raise the paneling and transfer of justices. Say Chief Justice no or the Boapayo a transfer judges be our motina cases be so. Yanko muni yanko. I said there have been reported incidences of the Chief Justice's direct interference with duly constituted panels with no explanations or public interest reasons for so doing. We consider the reconstitution of panels to be beyond the Chief Justice's administrative power and amounts to a direct interference with the impartiality and independence of duly constituted judicial panels. It was see cases where case na kwa na ye na se ye bema ruling na Chief Justice na ba o se o Mrs. Judge se take case ni so o se da bi embra emma Chief Justice kwan so won de ni tumi ebe sesa judges constitutionally no ya mo kwan so mo ntina case so embra ma Chief Justice a tumi no nti onya tumi no we hia na odi se ejuma no o se the Chief Justice's constitutional and or legal authority to constitute and reconstitute panels for the hearing of cases must be guided by the constitutional and common law principles which regulate the exercise of such power, and so is the power to transfer judges and other officials of the service. The fundamental inability to distinguish between the exercise of her administrative power and interference with a panel's judicial work confirms her incompetence, quite apart from the dangers that it poses to the integrity and independence of the judiciary. Inability to understand or perform the duties of an office adequately constitute incompetence. It is my contention that reconstitution of judicial panels is the ultimate way to interfere or control the impartiality and independence a panel's judicial work guaranteed by Article 127 and 1913 of the Constitution 1992. The Constitution is clear that no person, including the President, Parliament, and the Chief Justice, shall interfere with judges or judicial officers or other persons exercising judicial power in the exercise of their judicial functions. To address a Constitution, President impo, Member of Parliament, Vice President, Supreme Court Judge, and a Chief Justice nanka say wodi to me so be interfere in judge bi ejuma woye. It is say judge certain case so ni ebema ruling on the case. Na Chief Justice didn't to me aba be sesa judges ne free case ne so no. E ya de bi a Chief Justice ne tiamra because embra say uni to me say obeba judge bia uye Chief Justice there. Na so uni to me say judge bia asem no obebem. Inti cases ben and I can say Chief Justice no edi say juma no. The first one Opuni trial. Dr. Opuni ni case no. Or say the ongoing case involving Mr. Opuni, the Republic, and Stephen Kwabena Opuni, Seidu Agongo, Agriculture Ghana Limited, is a glaring example of the Chief Justice abusing his administrative powers to reconstitute a duly constituted Supreme Court panel that is seized of matter on the judicial side. In this case, Justice Honyonyega, who presided over the matter at the trial level, proceeded on retirement. The trial was reassigned to Justice Kwesi Anochijima, who at the time presided over the division of the High Court in Accra, before which the case was placed. The court presided over by Anochijima J ruled on April 4th, 2023 that the trial should start afresh, de novo. Considering the need to observe witness demeanor and the fairness concerns raised by the defense, this has always been the practice in criminal trials, in contrast to civil trials, where the parties had the option to abort the proceedings or start the trial de novo. This common law position is reiterated in the Republic versus High Court Criminal Division, ex parte Stephen Kwabena Opuni et al. Civil motion number J587 2023. Judgment delivered on 24th January 2023. The judge's ruling therefore fell within the expectation of many legal practitioners and judges. The Attorney General appealed this ruling at the Court of Appeal. On July 3, 2023, a 3-member Court of Appeal panel led by Justice Philip Bright-Mensah with Justices Jennifer Abna-Dadzi and Ernest Owusu-Dapah. Remember, let's continue. And Ernest Owusu-Dapah overturned Justice Jimen's ruling. The Court of Appeal directed that the High Court should adopt the proceedings from the trial conducted by Justice Onyenega, emphasizing that the High Court's decision to start the case afresh was a misdirection. In the meantime, the Chief Justice transferred Justice Anoche Jima to Kumasi and moved Justice Abuaji Tando from the High Court in Winneba to replace him. Several commentators linked the sudden transfer of Justice Anoche Jima to his disagreement with the Attorney General on commencing with the trial de novo. They publicly questioned whether Justice Anoche was transferred because he could not be trusted to conduct the trial in a manner pleasing to the Attorney General. Very simple. Dr. Oponi case by MPP for Dr. Oponi Yobia no here NDC time no na no here kuku botso. Nti MPP for no mo person mo chini tum. Na case no court na judge na oti case ni so no Hunyonyega oko friend saying retirement. Nti ye the case no ba be share judge fufuro nsa na friend Justice Anoche Jima. Nti Justice Anoche Jima betena case ni so no ka say oh we dey a criminal case. Na criminal case bia no say ye the judge fufuro ba. Case na was ye share fresh. Ati I say a normal practice. Nti no yen share case na say fresh. Judge fufura wo no ba ya wo ba betena case no okọ ne me judge fufuro. Nti obi ambra manim. Na ye mbra mekan case no fufuro. Nti judge ne kan sa asem no anye Gofredame de. Because Gofredame hu said abi Dr. Oponi e was omo chi ne tumi ntem. Se judge ne ka se omo nhye case na se fufuro a udi agra e bia sa time a case na because na Dr. Oponi embre betwem yentumi nchi ni ntum. Nti ho na Gofredame e di case no e call appeal. Sa ruling na judge ne man no o de call appeal. Say the e koso ni e na judges no a wo motena case no so wo appeal no e kan say oh judge na wo ka say yenhye case ase foforo no judge no na asem enye de. Nti case no won to aso. Send your judge Onyenega baby a wodu ye no wo montua case ni so mfiri ho. Nti wo monko back to judge eye Anoche na Anoche no entua case ni so mfiri ho. Nti wo ye say wo monko back to Anoche no e ho na Chief Justice no e transfer Anoche yi e free en crime. A say case no ntumi ntina so biom. Nti e ho na Ghana for ka say eh na say Anoche ruling na wo man ya wo kan say yenhye case na se fufuro ni ntino. Say Chief Justice ne hu ne said that be Anoche wotena case ni so a ebia na wonche Dr. Oponi ntum te say na allegedly omo person mo che Oponi atum. Nti eye one of the case a wo kan say Ghana mrachre say ma Chief Justice emba judge asem. Nti sa de we a Chief Justice ye na say indirectly no wa ba judge asem no emu. And I hope you understand. Nti Oponi ni case no ni explanation a wode man no. Ati ase. Nti reconstitution of panel for hearing of Dr. Oponi's appeal. I say Dr. Oponi's legal team led by lawyer Samuel Kujo filed an interlocutory appeal at the Supreme Court on July 7, 2023, arguing that the Court of Appeal erred in its judgment. Several months after the appeal was filed, parties appeared before the Supreme Court on January 17, 2024 for a hearing. The court presided over by Justice Mariama Owusu along with Justice Yaudako Asare Emmanuel Yoni Kulendi, George Kingsley Kumsin, and Henry K. Kofi ordered the parties to file written submissions. On May 8, 2024, the Chief Justice controversially reconstituted the panel hearing Dr. Puni's appeal, presiding over the new panel, which included Justice Mariama Ousu, Henrietta Mensah Bonsu, Yaldakon Asare, and Enes Gau. Only 2 of the original 5 justices remained. Lawyer Samuel Kujo objected to the new panel, citing Article 1573 of the Constitution, which stipulates that a judge or panel cannot withdraw from a case after hearing arguments until judgment is delivered. Inti osi case ni wiye ye kan say Dr. Puni appeals court ka say yenko to case ni so no na Dr. Puni lawyer e ka say dabi appeals court judges na ye mistake into no they go Supreme Court. So they go Supreme Court no embre be mu several months and a Supreme Court ebe ka say oh obi antro ne nsem ye den embra. Dr. Puni o lawyer entro ne nsem embra den ti o feel say appeals court asemo a wo kan say yenko to case ni so ma yen sha ase foforo no. Control bra de ntia appeals court na ye mistake. Attorney General enso nko trombra enhu no say ebia appeals court no omunye mistake. Enti judges no be betena case ni so a omoye so wo mo be ma ruling na ye nim say Chief Justice ni kokon hu ruling na judges ni ba be ma wo say de yu. Ti judges ni yes mo be ma ruling na na Chief Justice no e ba be sesan judges no. Supreme Court judges no oba be sesan wo mo on the same Opuni case. Ti ona Opuni lawyer e ka tre eye Supreme Court Chief Justice say de wo ye ntwa ye Ghana mra article 157 etre say judge enya sha say otie asem a e wo say otie asem ni wie ewie eni kwan say ye transfer judge no nti Chief Justice say de wo ye ntwa ye but say na ye be kan no you have your or say you have your say, I will have my way. Inti Dr. Punini Crawford ne lawyer no, he had his say, but the Chief Justice had her way. Unze ye konsem ni mun nsem bebreba. Nsem APP. Inyama Chief Justice na ya Yesusu se no hunti yempa me no. Nto say, despite his objection, the Chief Justice led panel overruled him, and the case proceeded with a new panel. On June 19, 2024, the Supreme Court dismissed Dr. Opuni's appeal, ruling that the Court of Appeal was correct in directing the High Court to adopt the previous proceedings. There was no administrative authority for the Chief Justice to reconstitute the panel in the Opuni case without assigning any justifiable reasons. It once again generated public and adverse discussions on the judiciary led by the Chief Justice. The Chief Justice literally ran a one-person show by exercising unconstitutional powers to interfere with the judicial functions of a duly constituted court panel that had previously issued directives to the parties. Inti the issues are ye rezi and no. Now another case, the Ablakwa case. Not just say Okujato Ablakwa case ekokopie wonenim and also ma me no ye no bukatabi. Yenkonko ready, interesting one. Some say, mo see yenkon sem ni mo. Inti ye kum. Say mope. Mbe nya papa. I say the Ablakwa case. On 25th June 2024, lawyers for the Honorable Member of Parliament for North Tongue objected to a reconstituted panel of the Court of Appeal. They contended that the best of their knowledge, the panel to which the case was assigned are Senyo Jamefe presiding, Efiasewa Asari Botwe, and Acha JJE. They, however, observed that the panel had been reconstituted by the substitution of Jamefe and Acha JJE for Pamela Cranton presiding and Kweku Aka Boafo JJS, leaving Asari Botwe JE as the only justice of the original panel. The reconstituted panel dismissed the objection, holding that there was no evidence to suggest bias as the basis for the reconstitution. Subsequently, however, evidence emerged that Justice Jamefe was initially empaneled to preside over the matter, but was written to return the docket to the Chief Justice. Justice Senyo Jamefe will be subpoenaed to testify in the matter. Inti munya mokai ablakwa okujato ablakwa any Kusi Boateng case no. Case ni koso ebeha na say yaba besesa judges. Na ablakwa a lawyer ka say yentwa ye judges that tina case so judge no nka say wo yare. All of a sudden danger na wo sesa we judges are kofa ba se munya mo be ka say issues e ba e kra ne say some of the judges are dey or mobile ne kra na say na Kusi Boateng eye omo sofu said yen munya mo kai there was an issue like that. I stand to be corrected. I think there was an issue like that. Ena abrakwa a lawyer say ka say yentwa ye judges setina case nso de dada no omo ye fair den jana go fa judges bia omo ye biased. Chief Justice Ninti or say that be masa media de ebeye na ebeye si de ebeye ene ebeye ena omo eye de omo beye no na or say that time no Justice Senyo Jamefe or hwa na yetro nkrata man say case no ombra onjai case ni mu enti say omo tenase a omo frɛ Justice Senyo Jamefe na wababa be yi nsɛm ano say sebe o katre Chief Justice say wo yare no ntumi indi case no enti na yeti case ni free ni nsɛm ana obeba be yi ne ho ano enti ohwa eno nso one of the cases ye raise against the Chief Justice. Now another case the Republic versus Elisha Mahama and 2 others. Okay, and also another case of original so I work as a Chief Justice no we there suban fin biedi into yempameno. I say on Wednesday, the 22nd of May 2024, the prosecution in a case numbered UW WA DC B110 2024 Institute Republic versus Elisha Mahama Agbanyiche and 2 others appeared in the High Court, sitting in Wa for the hearing of the case. It was announced in court that the Chief Justice had directed that on the completion of the committal proceedings before the Wa District Court, any further proceedings shall be transferred to Kumasi. This directive to transfer the matter to be heard in Kumasi justly outraged many indigents of the Upper West because of the venue of the crime and the residence of the parties. The Chief Justice's decision was questioned on grounds of reasonableness, given the fact that the hearing of the matter in Wa was proper, more convenient and understandable, having regard to the High Court's Wa's proximity to the place where the crime was committed, the residence of many of the witnesses and also the prosecution. Although the Chief Justice subsequently rescinded her decision, her exercise of administrative power to transfer the case to Kumasi was in the instance exposed as arbitrary. Now, what's the case be by between Nkrophobia asem no esi wa case no one year di case no. On meti an say Chief Justice say wo transfer case ni free wa embra Kumasi. And no more involved in the case and say na yen ti Kumasi bibi ani ho e course wo Kumasi. Case abe ye di no wa o se yen fambra Kumasi mbra mbedi Chief Justice na dey na yo akwa say bibi esi won crying now the case na ko en crying Accra High Court na mu di case na Chief Justice say wa transfer case no akọ ebia Upper East obeka say na wo Upper East one na oni mo ho ade na e ka no ensi wo Upper East esi won crying en crying na mu di mu case na ase nyansa nim inti ho na woka say the reasonableness of the thing that Chief Justice ni ye no ase no obi anti ase na tre say nyansa ni ade a wo ye ni mu inti enkrofo ni complaining say case na wo transfer fee wa akọ Kumasi ne yenti ase na nyansa nim ye na yenti Kumasi na opese ye den na ekọ Kumasi koko di case no e na Chief Justice na nkasa ba be hu say wa ye bone e na ono asanso ba be sesa na no inti wo tre say e wom say Chief Justice sesa na no de e trem say o sesa ne decision no na so the fact say wo dwen ho e ma wo ka se yenfa case ne nkọ Kumasi kra tre say maame no sebe or run a one man show and a one woman show. One sheda and dream ho papa sa enkrofo na complainia na kasti obema case na Kumasi. Intino and no cratre say onye obi a ese fata say sa position no ye de hye or ye incompetent. I say usurping the functions of the rules of court committee. It's another one they say embre bi wo ho a court no omo committee a omo di so yɛse maami otumi de ne pɛ ɛbɔ mbra no ɛden egu nti ɛno nso yɛ another reason a ɔse maami yɛmpame no yɛnkenkan ɔse in April this year 2024 the Chief Justice issued about 10 practice directions to regulate some aspects of practice and procedure of certain courts in Ghana. This function is by Article 157 of the Constitution reserved exclusively to the Rules of Court Committee. In the exercise of such function by the Rules of Court Committee, the said committee is required to make the rules by constitutional instruments, but not by any other instrument. The practice directions issued by the Chief Justice to regulate practice and procedure in certain matters in some of the courts were neither issued by the Rules of Court Committee nor by constitutional instruments as prescribed by the Constitution. In issuing the said directions, the Chief Justice usurped a function constitutionally reserved to the Rules of Court Committee. Nti sɛ nea wɔka no, yɛwɔ ekuo bi wɔ hɔ a yɛfrɛ ɔmo Court Committee. Ɔmo na ɔmo hyɛ mbra a lawyers endi ɛwɔ court. Sɛ bi ɔmo betumi aka sɛ lawyer oba court a hyɛ mpɔboa sei, lawyer oba court a ma mo nhyɛ wig, mo nhyɛ wei. What you say? Ɔmo kɔ court ɔmo wɔ mbra a ɔmo di so. Akwa sɛ wo kɔ school. Etumi kyerɛ sɛ wo uniform ni nye sei, wo uniform ni nye sei. Enye Chief Justice na hyɛ saa mbra no. Chief Justice ne de ne mpɛ ɛba bɛhyehyɛ mbra a Ghana Constitution kyerɛ sɛ saa mbra ne nyinaa no ɛyɛ court committee no ɛna ɛwɔ sɛ ɛhyɛ. Nti Chief Justice no de ne pɛ aba bɛhyɛ saa mbra na one ma court committee anhyɛ saa mbra no na kyerɛ sɛ wagye court committee no etumi ɔno de ne tumi atena court committee no etumi ɛso. Entwa yɛ sɛ Chief Justice bɛyɛ bibi saa. It is important to add that the Chief Justice issued the directions at a ceremony to which several persons were invited and state resources expended to launch them. In so doing, the Chief Justice willfully caused financial loss to the state, as the said directions have no force of law. The disregard of the Constitution's clearly laid out process for issuing practice directions fits into the pattern of the Chief Justice's utter contempt for due process, rule of law, and a constitution that she is enjoined to protect, preserve, and defend. Inti, senior Chief Justice no, oma rules ne kra no, enye baby pebi, ase, obi yako programma siya jane se, wababe announce, we asem, Chief Justice, say sani yadi. Now, another one, making of administrative guidelines unconstitutionally. By Article 159 of the Constitution, the Chief Justice is empowered to make regulations for the efficient performance of the functions of the Judicial Service and the Judicial Council. The constitutional provision, however, says that such regulations must be made by the Chief Justice, acting in accordance with the advice of the Judicial Council and with the approval of the President and by constitutional instruments. Further, by Article 157, the Rules of Court Committee is empowered to make rules and regulations for regulating the practice and procedure of all courts in Ghana by constitutional instruments. In May 2024, when the Chief Justice launched her practice directions, they were launched with administrative guidelines. These directions were made contrary to the constitutional provisions which regulate the making of such guidelines. Those practice directives that were related to the practice and procedure of the courts were not only to be made by constitutional instruments, but also by the Rules of Court Committee. The failure to use a constitutional instrument shows a disdain for collaborative rule-making and a preference for running a one-man show, a one-person show. And also, you say, Mbrebi woho, administratively, no, I was a Chief Justice ni make, and the Mbrana man kwanse also make. But Mbrana say, o make sa de na, enyo no pe. I was a one Judicial Council in a tenase. I was a President approve. I was so here by constitutional instruments. I was a court committee ne kra eka ho. Na so Chief Justice nim emma eye emra we ono pe. Oni Judicial Council anka ho asem. President ne approve. Rules of Court Committee no enso ensa enka ho. Na to say a one man show, one person show and a Chief Justice no all run it. Now another case or say Daniel Ofori versus EcoBank. Inti original case we nso na or the akase Chief Justice no yempame no e na Chief Justice ne ye. I say in July 2018, Daniel Ofori won a case against EcoBank Ghana Limited. The judgment was delivered by the Supreme Court. The bank made several applications to the Supreme Court to have the judgment set aside on grounds of fraud. The Supreme Court dismissed all of them. In one such application, the Chief Justice was empaneled to hear the application, but Daniel Ofori's lawyers objected on the ground that the Chief Justice had virtually made pronouncements in an earlier judgment against Daniel Ofori, which were reflected in some of the dispositions the bank relied on to pray the Supreme Court to set aside its judgments. The Chief Justice refused to recuse herself, resulting in a judgment of the Supreme Court disqualifying her from sitting with the panel to determine the bank's application. I say, undoubted, the bank then commenced fresh proceedings in the High Court, General Jurisdiction 6, to set aside the judgment of the Supreme Court based on the very fact rejected by the Supreme Court in the several applications filed by the bank. The High Court presided over by dismissed the bank's application on grounds of abuse of the process. The bank appealed to the Court of Appeal and applied to High Court for stay of execution. When the Chief Justice took office, she transferred from the High Court General Jurisdiction to General Jurisdiction 8 of the High Court. The High Court, now differently constituted, granted an application by the bank for stay of execution, and its ruling suggested the stay granted applied not only to the ruling of the High Court but also that of the Supreme Court. The Supreme Court later clarified that the stay ruling of the High Court could not extend to the Supreme Court's decision. The Chief Justice also transferred garnishee proceedings pending in respect of the Ofori and bank and in respect of such commercial division of the courts of the court had made an order nisi to the High Court General Jurisdiction 8. After the decision of the Supreme Court, the bank returned to the same High Court General Jurisdiction 8, presided over by the same judge who granted the bank's first application, which was blunted by the Supreme Court's decision, and made the same application. The High Court, completely oblivious of the Supreme Court's ruling to which its attention was drawn, granted the bank's application for stay of execution, and in it reiterated expressly that the High Court had stayed the judgment of Supreme Court and also the garnishee proceedings transferred from the commercial division of the court. There can be no doubt whatsoever that the Chief Justice is the reason for the seeming boldness of the High Court judge, whose attention, having been drawn to the Supreme Court's ruling that the High Court's earlier ruling could not affect the Supreme Court's ruling, still went ahead to brazenly and purportedly stay the Supreme Court's ruling. If the Chief Justice's intervention was merely suspected, it is reasonably well established by the transfer of the case involving the same parties from the judge in Commercial Division of the High Court 7, where the garnishee proceedings were pending, to the judge in General Jurisdiction 8, who was willing to stall Mr. Daniel Ofori's right to enjoy the judgment of the High Courts. Now, this one is quite cumbersome. Now, I see in 2018, that time 2018, no, na Chief Justice we na onye Chief Justice. That time na oye judge, it was Supreme Court. In 2018, Papa B, I friend Daniel Ofori, or we need case against EcoBank. EcoBank ye bank case ye Ghana. Now Supreme Court NMA ruling no in 2018. Now bank no several applications say nanka judgment no yembongu papa ni case awe wini no yembo judgment ningu in the name of fraud. Supreme Court ebo sansem ni na egu ye said dabi papa no we wini case no yembongu. Now in one of the applications, okay, na Chief Justice no oka judges ne ho. That time no nye Chief Justice nti mo nhye ne nso oka judges ne ho. Na omo te say na or make comments comments are now all man no na wo kaseti ya papa na we win case no inti enkrofo na omo request say yembo case ningu no omo yusu chief justice no sa time no onye chief justice but omo yusu onu nenum nsem e ka say mo judge ba ko kra asem a wo ka fa case ni hu ni eno kra trese case na nkoso ye nti munye de mumbongu but nini na echi no papa no e ba court omo ba court fufro na papa ne ka say enam case a enam asem a chief justice no ana sa time no onye chief justice but enam asem a judge we ya kan nti no judge no oye biased yenyi ni free case ne so inti sa time no onye chief justice there inti judges a omotena case ni so na hu say indeed maame no ye supreme court judge but nsem a okan na ntwa ye inti also ye ni free so inti ye ni free case ni so the Supreme Court disqualified her from sitting on the panel inti emre ba betwemu bank no ehyaase fresh proceedings call high court na bank ne call high court no bank no call high court ko katre high court say wo mombo Supreme Court insemingu what be that Supreme Court ama decision ni call high court say high court ni mombo Supreme Court insem no enye den engu based on the very facts you rejected ye by the Supreme Court no ti asemo de akwa to Supreme Court animo Supreme Court abo asem negu no bank na call high court say high court embo Supreme Court insemingu omo file applications bebre but high court no e dismiss bank no ni applications no on the ground say a abuse of process who the case akwa to Supreme Court enim Supreme Court say entwa ye wabo wasem egu uwie waba me high court say the same issues how they call Supreme Court wabo egu no waba high court say me high court no me mindi maw that be o abuse process no inti high court ni bonsem ni guye inti yesi embra chief justice wey se wono na o ka bia ma bank no ene ema ye ni free so embra na wo ye Supreme Court judge no ema ye ni free so e wo case no ye ni free case ni so but na mbre beba that time no onye chief justice inti no ntumi nkasa inti ye man the selection a wo ba beda ni chief justice no ehwa na first thing one of the things I wo ye and say what transfer case no from the high court your free BB high court general jurisdiction 6 to general jurisdiction 8 of the high court into your transfer case no from high court back on the call high court fufro as a high court fufro no judge fufro enetina case ni so into this ejuma ninti no e she judge no nkran say en yes ade a won di case no tio o di case akọ Supreme Court aboegu or they akọ high court say Supreme Court aboegu dey ntia na o di the same case ebrem say mindi e dey na o pese o yeyi ye dey asema akọ to papa enim o papa aboegu o wie ye no dey akọ uni apanyi enim so onum ndi umbu ade uni apani say na wo bu ade o dey akọ me papa enim me papa abo asem negu o wie o dey ba me manim he that be a abuse omo file ya high court bonsem ni na egu ye twen ye chief justice no no can case ni ho ayi ni free so no because of comment bia we make ya clearly no show biasness into no obabe dani Supreme Court na oyi case no from one high court they call different high courts e the judge fufro ekokot na case ni so instead of judge fufro no ebeka say oh dabi me nua high courts abo asem na egu ntimi nso mebo asem na egu no judge fufro ni hu say dabi say Supreme Court judge and a chief justice any the case no transfer case na ba me high court for dia na tre say o pese case no midi nti e she judge no nkran e ma judge no ekokodi case no nti wo hwa o tre say chief justice ade awaye no ntwa ye etiefo Dr. Prof Azar ne nsemu a wa trotro reasons inti a was chief justice no yempame no eno ena ededa mo animi inti no montre mo adwo comment box ni mo bedase